Okay, so moving on now to the judiciary. So we have, again, traced the development of the class so far. We started with the Constitution, background ideas, debates, arguments, the system that it created and the way that it's developed over time with federalism, civil liberties, and civil rights. Now the major institutions, Congress, the presidency, now the judiciary, okay, the federal judiciary, because this is American federal government. So as with the other major branches, we will look at the Judiciary and the Federalist Papers. Again, Federalist Papers arguing for ratification of the Constitution, therefore defending and also explaining the rationale for why the different institutions are designed the way that they're, why the way that they are designed the way that they are, explaining a lot of different things, obviously all sorts of features of the federal government, the Constitution, the way that it needs to be. But when they focus on the individual branches, it's often very illuminating, explains to us why they have the specific design that they do. And the key point about the judiciary, the federal judiciary, is its role is what we call judicial review, okay? It looks at acts of the other branches of government and decides whether or not they're constitutional. That can be acts of Congress, that can be executive orders, that can be acts of the states, including state constitutions, okay? And the decisions of state Supreme Courts. Remember, Brutus identified that feature of the Constitution very clearly and was, bothered by it, and said that that's one of the problems, is that this new federal judiciary that's created by the Constitution will be supreme over and will trump our state constitutions and our state Supreme Courts. And he was, of course, especially concerned about the idea of the state constitution, because when people get together at the state level and write the Constitution for their state government, if that falls afoul of the federal Constitution, it's unconstitutional. But the mechanism for identifying that it does fall afoul or contradict the federal Constitution and therefore is unconstitutional and therefore needs to be struck down and made so that it's no longer a binding law, the mechanism for that is judicial review, having it challenged and brought before the federal judiciary, ultimately the Supreme Court, and with state Supreme Courts or state constitutions, it goes straight to the Supreme Court. And the Supreme Court deciding, yeah, this contradicts or violates the national federal constitution, therefore it's not a law. So judicial review rules over all these things, can review and decide whether or not any act of government is constitutional. Other branches of the federal government, the states, okay. And in order to do that effectively, one of the key ideas here is the notion of an independent judiciary. Okay, again, we're talking about the federal judiciary, individual states. Many states actually elect their judges. Okay, but all members of the federal judiciary, the Supreme Court, and also the other levels, which we'll talk about in a second, the other courts in the federal judiciary, they all serve with lifetime tenure with good behavior. Okay. With good behavior, that is effectively saying they have lifetime tenure. They cannot be removed from office, okay? There are a few extremely egregious, bad, really unmistakable examples of corruption that may lead to them being removed, but it really effectively never happens, okay? And it certainly never happens because they're making things that people think are bad decisions, okay? So an independent judiciary, the notion is they are not dependent on the other branches of government to stay in office. Obviously, how do federal judges get there? They are appointed by the president. They have to be confirmed by the Senate. So the other branches put them there, and that power of appointment is divided or shared by the president and the Senate, okay? But once they're there, they have lifetime tenure. They never need to be renewed, and they never therefore have to rely on the other branches of government and keep them happy in order to stay in office, stay in their position as a judge, okay? And this is entirely by design. This is to create, again, what Publius calls an independent judiciary, again, separation of powers, checks and balances. The judges, the federal judiciary cannot do this if they have to rely on the other branches for reappointment, or for worrying about their salary. Some of these essays in the Federalist Papers deal with how to set the salary for the federal judges. We don't really need to worry about that here, okay? But it's an independent judiciary, which means once they are in as a judge, they cannot be removed effectively, okay? And that again is to make it so that they don't need to worry about either of the other branches, anyone who could remove them. And of course, they are never elected. They're not elected to begin with. They never have to be reelected. So they don't have to worry about public opinion. And again, that is very much by design, because a big part of what they're supposed to do is protect the rights of minorities against majorities that may be passing laws that violate those rights of the minorities, okay? We'll come back and talk about this in a second when people debate what exactly the judges or the judiciary should do, okay? So they have this kind of permanent tenure. They are there, once they're in, they are almost impossible to get rid of. Of course, we've had some kind of high-profile cases recently of Supreme Court justices dying while before they retire, and then this becoming an issue in election years and so on. Okay, so they have this independence, and they have these lifetime tenure if they want it, but they are dependent on the executive to enforce their rulings or on the legislature. Okay, so Publius says, although they have this power, it's not too much power because they have, as Publius puts it, no influence over either the sword or the purse, okay? Sword here referring to the executive power to actually carry out these decisions. The purse being Congress's power of budgeting. Another way that you can make these things a reality is by tying federal funding for things to compliance with a Supreme Court decision, okay? We talked about this with the Civil Rights Act of 1964. That was effectively what ended segregation in Southern schools and really Southern governments and Southern society generally, was saying from now on, any state government that segregates, as all of those Southern states did, will not receive federal money for education, but also for other things. And that, tying that funding to compliance with the Supreme Court decision in Brown v. Board of Education, that was what finally made it a reality, okay? So the Supreme Court could rule in 1954 in Brown v. Board of Education that segregation was unconstitutional, but they couldn't do anything. Nothing at all happened until President Eisenhower nationalized the federalized the National Guard in Arkansas and used them to desegregate a school. President Kennedy did that with a university here and there. And then Congress eventually passed a law saying funding for these things is dependent or contingent on compliance with this Supreme Court decision. Okay, so the Supreme Court could say segregation violates the 14th Amendment. It is unconstitutional. It should stop immediately. But they had no real way of enforcing that or bringing that to become a reality. They had to rely on the other branches for that. So although they have this tremendous power to say what is and what is not constitutional, they can't really do anything to enforce their rulings. And there was a famous case where Andrew Jackson disagreed with the Supreme Court and said, Mr. Marshall has made his decision, now let him enforce it, okay? Because they're relatively powerless in terms of what they can actually do directly, okay? So it's meant to limit the power of the other two branches. Publius in the Federalist Papers says especially the legislative branch because of the ways that majority opinions and dangerous majority opinions may express itself through the legislature, through Congress, but it's not superior to Congress because, again, checks and balances, separation of powers, they're supposed to be equal. Publius says, although it's meant to check Congress, it's not superior to Congress. It's only applying or interpreting and enforcing the Constitution, which, of course, is superior to all the branches, okay? So that's kind of the overview of the nature of the federal judiciary and its purpose in the Federalist Papers. Okay, Federalist judges or federal judges, as we've said, they are appointed by the president, confirmed by the Senate. They have lifetime tenure. They are never elected in any form. This is intentionally anti-democratic so that they don't have to worry about public opinion when they're making their decisions. Again, Brown v. Board of Education gives a perfect example. Imagine if the Supreme Court or half of the Supreme Court had to run for re-election in 1956. Okay, it would have been maybe very difficult for them to make that decision. In Brown v. Board of Education, if they had to worry about being reelected, and if they did, they may not have been reelected. Okay, so this is purely intentional. The notion to insulate them and protect them as much as possible from public opinion and from democratic politics, that is all very much intentional by design. Okay. Judicial review, obviously we've talked about this, that is their chief, really their only function. They are able to review the acts of other branches, decide whether or not they're constitutional. They are interpreting the Constitution. If something flagrantly violates the Constitution or flagrantly violates a previous decision, they can strike it down, okay? but they may just say this is done. Often, this violates the Constitution, this violates a previous decision, stop it. Oftentimes what they're doing that's really important is interpreting the Constitution, applying past decisions to new cases, okay? And therefore, like we talked about when we talked about the Constitution and how the Constitution is modified, there's the actual formal amendment process, but judicial review is also an important way that the federal Constitution is changed, developed, expanded in a way over time, okay? Court decisions can be trumped by constitutional amendments, okay? This has never happened. A constitutional amendment has not been passed in direct response to a particular Supreme Court decision. But although there is this anti-democratic mechanism here, mainly to protect the rights of individuals and minorities from possible majority abuse, and it is intentionally undemocratic, again, undemocratic by design, even anti-democratic, there is a constitutional mechanism for the people to overturn these Supreme Court decisions if they really want to. It's by amending the Constitution, which again, very difficult to do, happens very rarely, okay? But there is a way. The ultimate authority does not rest with unelected judges. Ultimately, it does rest with the people if they want to amend the Constitution, which again is very difficult, okay? So it's not an easy solution if the people really don't like the decision by the Supreme Court, but there is something there. There is an ultimate democratic means to change this or deal with it, okay? The legal system, we have trial courts and then we have appellate courts. The trial court, in terms of criminal law, the trial court is usually just trying to figure out what happened. And then the appellate court kind of goes back and looks at the original trial and makes sure that it was fair, that it was according to the Constitution, okay? So trial courts, in the case of criminal court, may decide whether or not a person committed a crime. And then if they appeal, the appellate court will look at whether or not all of the evidence that was allowed should have been allowed, or whether there was some violation of the defendant's due process in the course of the investigation or the trial or something. In the case of the federal judiciary, when you're appealing, usually you are starting oftentimes to get into constitutional questions, okay? The federal judiciary, especially when we talk about the Supreme Court deals only with constitutional questions, okay? It is not going back and looking at, was this, did this person really do this, or should the judge have allowed this piece of evidence or this piece of testimony? They are just discussing how to interpret the Constitution. Okay, so you have jurisdiction. That basically means who has the authority to decide these cases, who has the authority to try and make these decisions. There is original jurisdiction, and there's appellate jurisdiction, okay? You have criminal and civil law. Criminal law basically deals with offenses against society. Civil law deals with issues with individuals. Of course, sometimes you can have both, right? You could be tried for murder and sued for wrongful death. Or there could be embezzlement things that are, or things involving property crimes that are both crimes, and there might be a civil lawsuit as well. But criminal law generally deals with, even if there is an individual who is wronged in some way, the notion of criminal law generally is that the person has harmed society in some way. That's why in a criminal trial, it's usually the people versus whoever, okay? Civil law are disputes between individuals. They can be important in some ways. They can deal with very massive corporate issues of intellectual property or ownership of whatever, and they can be worth millions or even billions of dollars, but they are disputes between individuals or between private entities like corporations, okay? So those are two totally different branches of the American legal system. Criminal law, again, deals with not only violent crimes, right? All kinds of forms of theft, slander, things like that are not physical violence, but they are still questions of criminal law. And then civil law disputes between individuals or between private entities like corporations, okay? The federal court system, you start out with the district courts, then the Court of Appeals, then the Supreme Court. And in the American legal system, common law, you tend to have an important principle is stare decisis, let the decision stand. The reliance on precedent. When judges are deciding these cases, especially when we're talking about the judiciary and the federal judiciary, especially something like the Supreme Court, trying to decide whether or not something is constitutional, what they tend to look at are precedents. What has the court said previously about similar cases? and how can we take the principles that they applied there and apply them to this new case, okay? So it's not like the judges just get together and say, what do we think is the best outcome here? Or who do we like better? Or what do we think is really just? Or what do we wish the Constitution said? Or what do we think will give the best outcome for society over time? When we look at everything as a whole, what they look at is they look at previous court decisions, and of course, remember the Supreme Court, they always write a decision. They always write out their reasoning for why they voted a certain way. And there's a majority opinion that explains that. And people can write a concurrent opinion if they voted with the majority, but for a different reason, but that doesn't have as much, to keep it simple, they write a majority opinion. So you don't just go back and look at a Supreme Court decision from 1980 or 2005 or maybe 1802 or something. You don't just go back and look at the decision and see how they voted and who won and try to guess what they were thinking and how that might apply to the current case. They have written a decision explaining their reasoning. And of course, the further in time you get, they're looking back at previous decisions themselves and explaining that reasoning based on these previous decisions. So there tends to be a lot of reliance on precedent when the Supreme Court wants to make a decision. They look at these previous cases and they say, how would they apply here? Okay. That being said, there are obviously disagreements. There are 9 members of the Supreme Court now. They vote differently on different cases. They write out there is a majority opinion as well as a minority or a dissenting opinion. Okay. Obviously, they do disagree, so it's not like this is all straightforward. But again, what they're doing, at least as a matter of form, is relying on precedent, relying on previous cases and explaining this is why I think, based on these Supreme Court decisions in these previous cases and the principles, the legal and constitutional principles that they articulated in these earlier cases, this is why I think they mean we should vote this way here, okay? People who are a little bit cynical or less convinced that this is the real motive of the Supreme Court, that it really works the way that it's supposed to according to the Federalist Papers, they tend to think that precedent is something that isn't necessarily made up, but that there are many Supreme Court cases at this point, and that people kind of can pick and choose to get an outcome that they want for different reasons. And we'll talk about that when we talk about the theories or models of judicial behavior, okay? Here is a good, this is from your textbook. This is just a good, visual representation of what happens. You can start out in the U.S. District Courts, go to the U.S. Court of Appeals, and then it can go to the Supreme Court. Again, the Supreme Court is always going to hear questions of constitutional law, not whether or not a particular piece of evidence should have been allowed, based on giving somebody a fair trial. And then here is the method or the pathway through the state courts, okay? State trial courts, intermediate appellate courts, state Supreme Courts, where usually the state Supreme Court might be looking at the state constitution, and then you can appeal from there to the U.S. Supreme Court. And again, the state Supreme Court decision may have been the right reading of the state constitution, but the state constitution might be in contradiction of or in violation of the federal constitution. So the U.S. Supreme Court may strike down that state Supreme Court decision, and in the process then strike down that part of the state constitution that it was based on, because again, that principle of national supremacy, which again, anti-federalists like Brutus saw very clearly, knew that was there, and absolutely anticipated this, okay? But there's a good visual representation of how this works. And again, the 2 paths, through the federal court system or through the state courts. Okay, the American court system is, by design, it's an adversarial system, okay? What that means is that the courts are meant to be sort of an arena for two adversarial parties to argue and to try to, debate each other. And out of that conflict, and the notion is obviously that the judge is supposed to be an impartial arbiter, or a judge basically saying, this is irrelevant, or you can't say that, or we're throwing out this evidence for whatever reason. Through that impartial judge, the conflict or the struggle or debate between the two parties is supposed to yield truth and legal justice, okay? Maybe not always the justice that you think would be right or kind of pure or the best form of justice, but justice according to the legal system, okay? And obviously you have the trial by jury in the case of criminal cases, but sometimes for various reasons it may also, and when you get into some of these appeals cases, and obviously the Supreme Court, you're just arguing before judges. not only through not only with the jury. Okay, so the theory is that you have a conflict between these two parties. They debate it. They each side makes the best case that they can for their party or for their point of view, right? And the idea is you are not supposed to, if you're a prosecutor, you're not really supposed to worry about the idea that what if this person is innocent? You're supposed to make the best case that you can for the state. If you're a defense attorney, you're not supposed to really worry about what if your person is really guilty. You're supposed to make the best case that you can for your client, and the system should sort it out, right? And even if your client is guilty, if the prosecution cannot establish that according to the rules of the court beyond a reasonable doubt, then that's how the system works, right? The goal isn't to figure out who's guilty and put them in jail based on whatever people come up with in the spur of the moment. It's supposed to say, through this system of the court, can you establish beyond a reasonable doubt that this person has done this? Same with, again, civil law disputes over intellectual property or things like that. Each side is not really supposed to worry about, do I think that my client means well? Do I think they do good stuff in the world? Do I think that they should win? They're supposed to give the best, or sometimes they say the most zealous representation that they can for their client, and let things play out in that arena of the court and that struggle between the two adversarial points of view. And whichever one wins, that's the system, right? Or at least that's the theory. Most cases are settled out of court, okay? And that is where both parties, again, whether it's a criminal case or a civil case, both parties, through compromise, they reach something that they're happy with. So in a criminal case, the prosecutor maybe offers a lesser charge, less jail time. They don't have to worry about losing in a trial, and they get a conviction, and that serves their purposes. And the defendant, meanwhile, if they want to, they can try to take it to trial and try to get acquitted and walk away completely free. But if they don't, if they get convicted, then obviously they're going to have the more severe sentence, the longer jail time, and so on. So they have a reason to compromise and take the lesser charge, plead guilty, or maybe plead no contest to it, maybe do a lesser sentence, maybe do no sentence at all. And it's the same with civil disagreements. Again, if you want to take it to court and you want to argue that out and see the outcome, you may win and you may get exactly what you want, but you may lose and get nothing. So although the theory is that you'll have this kind of adversarial confrontation and this kind of agonistic argument between these two parties in court, and you'll arrive at truth out of that, in reality, usually some kind of compromise is reached outside of court. And so that's often how those things actually